30, 40 seconds. Great. So I'd like to welcome you to the last panel of the day, at least, and we have a very distinguished panel indeed. I hope it's the most interesting of the day, just to keep you awake at the end of the day. I'm Joel Guberman. I have the privilege of moderating this panel, and we are talking about consular do's and don'ts. If I have anything to say about do's and don'ts, and we're going to be less do and don't than we are telling you, more importantly, the consular officers are going to tell you what's happening at the U.S. consulate. If I can give you any advice at all, do treat them very nicely and don't piss them off at any point in time. To my immediate right is Mr. Hugh Williams, who's chief of the consular section, and I'm not going to go into great long introductions. He is replacing David Abel, who has laryngitis, and to his right is Morgan Hall, who is the e-visa consular officer. And to his right is Althea Braithwaite, who is a senior foreign service national, and I've been advised is the person who makes everything run at the consulate. So without anything else, I'll call upon Mr. Williams to tell us what's new at the consulate.
Good afternoon, and thank you for inviting us to this seminar on border issues for employees and executives at the Law Society of Upper Canada. I can tell you that these are exciting times at the U.S. consulate, largely because it's been an opportunity for a lot of the consular issues to take center stage in U.S. national security debate. And there's a little bit of groundbreaking that's been going on for us in some areas. We do have some experience in other parts of the world in some of these issues, but certainly not at the scale or magnitude of what we're having here in North America. Essentially, the sea change or the pivotal point that marked this change was September the 11th, 2001. And there are two operative words that are going on in Washington right now, effective, and they sort of call this, September 12th. From September 12th, the big issues for the Bureau of Consular Affairs, or sort of all of our immigration and visa regulations, was two things. One is that you cannot turn back the clock. The clock in the past was that immigration in the United States was an issue where we were kind of getting around to having a national debate on it. Where does it fit in with our culture as a melting pot? It certainly, people there knew that it had some national security implications, but certainly not at the extent that September the 11th proved. What that did was it forced the hand of the State Department to address certain issues and certain aspects of our policies, even our basic way of thinking, our procedures, our approaches, particularly sort of looking at security versus customer service. That's one of the fundamental issues that we're addressing now. Some of the other issues that are being confronted that were fundamental to us was in immigration in general would be things like family reunification, or the role of security, or certainly the facilitation of trade and commerce. What is happening is that we're thinking this thing through as we go along, but some key decisions have been made, and these key decisions are erring on the side of security. So that's kind of the context of what we've been going on. Maybe one day, once things settle down, we can have the national debate. In fact, I understand that the former commissioner for INS, who's that fellow who's the sergeant of arms at the Senate? What?
Michael Garcia.
Yeah. No, I'm not sure that it's him. Yeah. Well, there was a former INS commissioner who's now at Harvard University, and that's one of the things that he wants to do is to establish a national debate.
Ziegler?
Yeah, that's right.
Ziegler?
Yeah, yeah. But in the meanwhile, you're going to be seeing a lot of the bureaucrats pretty well trying to implement policies that are coming out of Washington, being coordinated as they impact upon you through Ottawa. And I can tell you that the relationship between Washington and Ottawa on these issues are very close. More often than not, a lot of times when we are considering various policies, the Canadian ambassador in Washington will be called in and say, this is what we're thinking, and, and they'll give a little feedback, that sort of thing. That's the world of diplomacy. But I'd like to speak just in some general terms and then turn it over to my staff to talk in specifics about some of the areas of some of these changes and operationally how we're making these various adjustments. Basically, in Canada, the way I came here, and yeah, Toronto was a reward for hard service in some pretty difficult posts, and I thought maybe my swan song, perhaps, everything was on automatic. Tremendous staff here. All I had to do was delegate, or people would tell me this is how things work, and that was true for the 3 months that I was here prior to September 11th, and then, as I said, things changed. From that point on, some of the automatic processes for facilitating trade and the movement of people and goods and services across the board. You've heard on your previous presentation of NAFTA, and there were some other sort of protocols that existed to facilitate commerce and trade and the movement of people that were in place. These things were working fine. It was all the right idea, a seamless border, all that kind of thing. These are new phenomena now that we have to think about the division line and whether rightly or wrongly people are thinking about that, and a lot of the measures that you're seeing are reactions to those perceptions. For example, Canadians do not need visas. And I will repeat, Canadians do not need visas to enter the United States. That has not changed. But what some of your family members and relatives, and perhaps maybe you yourselves, have experienced in some of the hype and the hysteria that is going on, is closer scrutiny at the ports of entry by immigration officials. And those are really identification checks. And now, before, where you just say, oh, yeah, I live in Hamilton and I'm just going down to visit some relatives in Syracuse. Well, that was all fine and dandy, but now inspectors are probably asking for identification. And that those kind of procedures or requirements always existed, but now you're seeing a little more on the enforcement side of those things. Then we had a whole category of, and we still do, of what we call our Visa Waiver Program nationals. And there are about 28 nationalities around the world where visas are not required for them to enter the United States. And historically, the way how it came out, there was a long checklist of for eligibility that they would have to meet in terms of the security of their travel document, their national and their national economy, and some other security features. And if they passed that litmus test, then visas were not required if they were traveling to the United States for 90 days or less for the purpose of business or tourism. That is still in place. Then there was another category that many of you would be familiar with, where landed immigrants of Canada who are also nationals of members of the British Commonwealth, they did not need visas either in order to enter the United States. There was a visa requirement, but that visa requirement, for all intents and purposes, was waived, and essentially all they had to do was prove that they were landed immigrants of Canada and the nationality of one of those British Commonwealths, i.e. a passport from Pakistan or India, one of these other countries. And then, again, in entering from Canada, no visa was required. As of March the 17th, that latter category that has been on automatic all these years and have worked quite effectively from a management tool will change. They are removing the waiver of the landed immigrant requirement, and now those nationals will need visas. Now, what does that mean? That means that if in the past you were a landed immigrant of Pakistan, I'll use that as an example, and you did not need the visa, as of March 17th, if you show up at Pearson or the Whirlpool Bridge or the Peace Bridge or what have you, and you will need a visa in order to enter the United States. If you do not have a visa, then you will be returned, or you will be denied admission and told to leave or to go get one. What does that mean for me? That means that I've got a lot more work to do, in addition, because when we knew these things were being contemplated, again in the September 12th mind frame, when all these things were placed on the table and they were deciding what are we going to leave on the table and what are we going to pick up and change, this was one of the ones we knew pretty early that they were going to pick up and change. But in the back of my mind, even though I looked around and we did some estimations of how many nationals or landed immigrants in Ontario would be affected by this change, and it was a couple 100,000. And we said, okay, well, the way we think we'll handle it is we'll allow those people to mail in their applications so that we don't have a run on my little dinky office over there on University Avenue just across the street, and there'll be an eyesore and traffic jams and all sorts of other things. Well, about a week or two after they announced that this was going to happen, effective March 17th, they said, oh, by the way, remember how we used to allow people to mail in applications? Well, we're not going to let you do that anymore. So again, yet another sea change where they've removed, it's what we call no personal appearance waivers. In the past, a lot of these things were founded on principles for management tools, because when the United States government, we were sort of operating those lean and mean days, and in order to get the work done, basically, we called it creative management, and you know, you just had to come up with best practices was the key thing that we used, and this is how you dealt with the volume or the demand of clientele with rather limited resources. Again, September the 11th has changed that, and some of these fundamental best practices are being rethought and, in fact, thrown in the garbage because of the security implications that they have. So that's one of the main things. Now, effective March 17th, the Canadian nationals will still not need visas. That's status quo ante, as is the visa waiver program. Those members, even if they are landed immigrants and a member of the British Commonwealth, but in the British Commonwealth they also are a member of the their visa waiver country, then they still don't need a visa. I hope I didn't pollute that too much, and that's easy enough to understand. But there are these various categories. That's one sense, and I'm gonna let Althea and Morgan talk a little bit more about how these various processes will impact on the various categories. Also, in the eye of the media, which is a sort of a domestic issue, is the registration requirement, and I want to talk a little bit about that briefly. This is something called the NSEERS, which stands for the National something, what's the S?
Security.
National Security Entry-Exit Registration System. NSEERS. That is a domestic requirement, i.e. being coordinated or generated out of the United States, where foreign nationals, residents in the United States and otherwise, must register. In the past, the United States did not have an exit requirement. We only had an entry requirement. You come get a visa, you go to the port of entry, the duration of status would be determined, and then the person goes in the United States, and we were on the honor system. So if you go in the United States and the immigration inspector at the port of entry said to you, well, how long are you going to stay, Mr. Smith? Well, I don't know. I'm kind of got to, go visit some people, and then I want to hang out a little bit. So maybe, 3 weeks. He said, okay, here's 6 weeks just for good measure. Come on in and enjoy yourself. Meanwhile, Mr. Smith is there. He really took the immigration inspector's comments to heart. He's having a blast of a time. 6 weeks come. Not quite ready yet. Somebody got yet another invitation before you know it. 6 months has gone by. Well, in the past, there was no mechanism, no effective mechanism for capturing how long the person was in the United States. And so now this NSEERS registration program and some of the other measures are being built in to sort of enforce some of these regulations that have been on the books in the past. Are we sort of awkward and rather heavy-handed in the administration of the policy? Yeah, it's not coming off too well. Will more countries or nationalities be added in various stages and that will have to meet various registration requirements? We understand, yes, that it'll be more rather than less nationalities will be added to that list. But we'll talk maybe perhaps a little more about that because I want you to sort of see it in the context. The context or the operative word of the context is security. And I was having a conversation with some colleagues today that what that really means for the career diplomats is that these issues are not unique to us or the way these issues are being worked. It just means that in the consular and visa area, it requires a lot of diplomatic efforts. I'd like to talk now about some specific visa categories. Some of the visa categories, I'll ask Althea to talk briefly about student visas, and then Morgan about business visas in general, and particularly e-visas, and then we'll open it up for questions. And then try to address your questions at that time. Althea?
Well, the student category is basically the F category. There's also the J's and the M's, but most of what we see is actually the F category, which is people attending academic institutions. And the one change that came about fairly recently is the need for the students to be registered by their academic institutions with the INS and State Department offices. So basically what happens is that if somebody's have been accepted at a U.S. academic institution, that institution is now required to enter that person's biographic data into a database, which is then downloaded through to INS, to State Department, and then to post worldwide. When a person applies for a visa abroad, we have to verify that that person's name exists in that database before we could issue the F1 visa. There's been some delay in that process only because it's been only started up on February 15th. And we have had a couple of applicants whose names have not yet shown up there, whose schools have already registered them, but because of processing delays have not yet shown up. There's very few numbers. But that's about the biggest change right now for the student applications. And that also applies to J's, which is the exchange visitor program, and the M's, which is the vocational student, and their dependents. They all dependents of those three categories also have to be registered with the State Department via their academic institution or program sponsor.
Now, let me just give you some framework for that. Many of you can imagine where that came from or what we were trying to fix in that process. The legislation behind it. You see, in our federal sector, we're responding to congressional mandates that have been given through various legislation that Congress has written to try and close loopholes and to correct some previous deficiencies in the system that have been used by enemies of our country to wreak havoc. And so in the student visa process, this is one of the things where it's the registration. Some of the responsibility has been put on the institutions, because one of the United States' main, and I'm not even really sure if it's an export, but one of the main things we had to offer was U.S. universities. I mean, this was really big time stuff, where for the world, where we were educating people, and you know, it was the outgrowth of the Cold War mentality, and we thought this was a great thing, but we saw where that area was being exploited as well, and so this is one mechanism designed to tighten down that that area. And Althea, can you? Well, actually, I'll let Morgan say a little something about special processing. If Althea and Morgan would talk a little bit about special processing, because this is sort of worth talking about.
Special processing for ease?
Oh, no, for anything, the SAOs and some of those things.
I defer to you on that.
All right. Well, there are certain requirements, again, that was put in place post-September 11th, whereby certain nationals of what we refer to as countries of concern had to go through additional administrative processing, basically additional security checks, before visas could be granted to them. The delays or the processing time for that could be anywhere between 4 to 6 weeks, depending on what the background checks had to be done.
Let me just say some of the genesis behind that was because the perpetrators of September 11th that came in, they were known to our intelligence services, but that information was not known to the consular officers in our database. So we had the technical problems of one data system not talking to the other. And so, again, in an effort to try and correct that anomaly, we had been working with the federal law enforcement agencies to share their databases, but you know, law enforcement officers, if you're not another law enforcement type, they'll blow you off. And then the State Department used to get blown off all the time by them. And then that was actually one of the reasons why I think the visa function is still with the State Department to this day and not with the Department of Homeland Security, was because we can say that our data system, even though we went through the whole processes of reviewing the applications and checking it against the information, it was garbage in, garbage out. So we did not know that the names that had been given to us were names of concern. And so what has happened in the wake of that is the law enforcement agency, the FBI, has dumped. First, they dumped 400,000 names into the State Department's database, visa database, and then we got a dump of 7 million names into our data system. And that created all kinds of problems for Althea and Morgan and the rest of the staff, because when a person named Harry Smith would come up and apply for a visa, and some other Harry Smith somewhere in the world was a no-goodnik, well, guess what? We had to figure out which Harry Smith are you. And or if your name was Hank Smith or H. Smith, same thing. And sometimes the issues inside the system, they might not have been really, you know, he was a terrorist or anything, could be DWI. Sometimes we wasn't sure what the information was. But in this context, the requirement or the procedures that had been set up required you to submit it to the law enforcement agency for a report, and that slowed down the application for the visa process. And that happened to a lot of Althea's student applications, and students were missing school deadlines and all sorts of things like that, and there was really nothing we could do about that.
Yeah, if I may, I mean, as a practical consequence, you may have noticed if you're making any of your clients or anybody's making an application and there's a hit, often you're fingerprinting these individuals, and the process gets, I guess, sent to the FBI for verification, and then back, and that takes a long time.
You had no idea.
Even though it's not the right person.
Yeah, you had no idea. Even when we came up with these systems that this is what we would do, well, we kind of forgot to tell the FBI And you know, when the FBI kind of got around, well, the same, you know, 17 people that might have been doing it in the past for the world, and now their workload has quadrupled, or you know, some other to an nth power. And so it took some while, and then the computers couldn't handle all the work, and you know, it was like a ripple effect to try and build the system back up to the point where it can handle these new phenomena. And meanwhile, people were stranded. But this is what was happening, and to some extent still does happen in government. And one of the reasons that we're trying to inform various audiences so that you can temper your expectations and make you an informed and educated body to sort of understand the processes of government and can kind of second guess some things or the reasons behind of what's really going on. Let's talk about ease, and we'll come back to some of these things.
Just before you do it, just for a gauge of the audience, how many people in the audience have dealt with the e-visa process, either now or in the past? So about a third. So some have and lots haven't.
Okay. Well, my name's Morgan Hall, and I work on e-visas at the consulate. I'm sort of a late addition to the panel as well, so I thought I'd talk primarily about what I do, the e-visa category. As Hugh said, Canadians don't need visas to go to the U.S. Normally, if a Canadian business person shows up at the border and is working for a Canadian company to go do business in the U.S., INS will give them B1 status.
What used to be INS?
Oh, I'm sorry. Department of Homeland Security, BP.
I'm not really sure.
Yeah, it's got a new acronym now. The former INS, the organization formerly known as INS, will give you B1 status. You enter and you don't actually have a visa in your passport. The e-visa is different. It's a kind of visa that's reserved for nationals of countries with whom we have a treaty of friendship, commerce, and navigation, which we have with Canada. We have the largest bilateral trading relationship that we have is with Canada. So it's a category that is open to Canadians. There are two categories of e-visas. One is for treaty traders, it's called the E1 visa, and the other is for treaty investors, the E2 visa. E just stands for the category of the law of the Immigration and Nationality Act, which Section 101E that covers the e-visa. The visa itself, as I say, is reserved for traders or investors. The E1 visa for treaty traders is granted to those companies or individuals who are Canadian nationals or companies that are majority Canadian owned who engage in trade with the U.S. and more than 50% of their international trade is with the United States. Individuals or companies who fit those characteristics would qualify for an E1 visa. The E2 visa, which is much more common, at least in Toronto, and in Toronto is where we handle all the e-visas for Canada. It's centralized in the consulate here in Toronto. The E2 visa for investors is reserved for those nationals or companies who are making a substantial investment in the United States. The company has to be majority owned by Canadians. The investment itself has to be ongoing. That is to say, it has to be a business that is up and running, a real and operating enterprise. It has to be substantial. It has to be for the benefit not merely of the investor, but of U.S. nationals or permanent residents who will be employed by the business. So it has to have an economic impact, either in terms of employment or generating economic activity in the United States. Canadian nationals who fit this category are eligible for the E2 visa. We get, last year we had about 1,900 of these that we processed in Toronto. As I say, the E2 is much more common.
All of Canada.
Right. It's centralized in Toronto. So I'll see applicants from Vancouver, Montreal. A great number come from Ontario, from the greater Toronto region as well, and all over Ontario. but we handle, of course, for all of Canada, and normally these were done in the past as mail-ins. Now, with the new requirement that Hugh mentioned, we can't do them as mail-ins anymore. They have to come in for a personal interview. So this is the big change that we're in the process of trying to adjust to now at the consulate. We're going to be starting to take e-visa applications in the mail, but once we make a decision that it looks like we're in a position to issue, we'll have to call the person in, the primary applicant in. The dependents probably will be able to do their interviews at one of the other posts in Canada, but it looks like the primary applicant will have to come into Toronto. If they're already in the U.S., they'll have to fly back to Toronto and conduct the interview there. So this is a new requirement that is going to affect a lot of people, but right now we simply are trying to comply with it as best we can.
One of the things that I hope you can see that will help you to understand the magnitude of what the U.S. government is faced with and their response to it. Look, we've talked about students. You know, several 100,000 worldwide, around the world, major institutions and that sort of thing, professors and, you know, bright kids and their future and that sort of thing being affected. Businesses, Morgan's talking about e-visas, major companies. I'm talking about the big three, the big two, the big one, everyone affected by these changes. Special nationals who are essentially, you know, friends of the United States for perhaps no fault of their own, affected by these changes. And the list just goes on and on. In fact, a day doesn't go by when we do not see sort of a side effect or an unintended consequence, or where we have to seek a clarification. Here's the regulation, and here's a particular category and the impact it is having. Are we sure that this is where we want to go? And when that kind of thing has been encountered with the question of enhanced security, I can tell you that the enhanced security argument has won out every time.
Right.
The one comment I wanted to mention also before we open it up to open the floor up to questions has to do with biometrics. Some of the actual visas and the technology that we're using now, technology is starting to be brought into the process more and more. You'll be hearing these things about biometrics and other enhanced technological systems being brought into travel documents in the visa process. I talked about the data sharing and the computers. This thing is really proliferating at a very rapid scale. And all countries are starting to experiment with these sorts of things and bring these requirements online. What impact will that have? Well, just like the impact that enhanced security screening equipment is having at airports, where there's more, explosive detection devices and all that sort of thing, the cost is being passed on to the consumer. And you're going to see more of that for travelers and business persons and that sort of thing, where the cost for these enhanced security features for helping to secure travel internationally will probably be also passed on to the consumer.
Of course, without being the least bit nasty and disrespectful at all, the big question, I suppose, is do all of these increased measures, and I think Heather must have raised this, in any way enhance the security of the United States, or do they just hassle the United States and cause it economic woe? I guess time will tell.
Yeah, our line for that is the jury is still out. And actually, a good part of it, the way we see it, those of us in government practice, is, how much will the American people tolerate? Because essentially, we've given mandates to the administration and our leaders to do the needful. And how long, and in what areas before we say, okay, enough is enough. then we just don't know the answer to that question. But we're taking some big hits, particularly in the United States. We talked about some of the some particular areas: the travel industry, trucking industry, automotive industry, you name it. Have the scientific and academic communities have made very legitimate complaints about the impact that these measures are having. The central or the federal government is not unaware about this, and the newspapers have certainly been bringing these points up as well. So we'll just have to see.
Yeah, we do have to realize now that since we're back at do's and don'ts for a second, and perhaps on the Canadian side, but less so, the rules have to be followed. There's no exceptions. There's no wiggle room by anybody. I think you said that fairly emphatically, but if there's a security check that has to be done and a businessman has to get across the border the next day, businessman's not going. I mean, don't go to clients and say, well, we'll see what we can do. You can't do anything. And you have to know that. That's not necessarily a bad thing. It just changes the way that we practice. We've got to be realistic in expectations, and we will certainly open it up to.
Yeah, and not the reason in part is because not only has the laws changed, where the authority of some of the persons out in the field that they may have had before, either the direct authority or the discretionary authority have changed, but also the will have changed. People are a lot more cautious these days, and you know, their heart might be in the right place, but their head's in another. And until this all sorts itself out, I think that Joel's right. It's probably not worth pushing on something that you're not going to win.
Heather, you have a question?
I've been meaning to ask you this question, actually. So,
She calls me about every other day. She could have asked this question any time she wanted to.
There's been some discussion that Homeland Security is going to have the authority to administer rules and governing granting of visas. I just wanted to know, have you heard anything to that effect?
Sure, there are rumors all the time. But I was telling Joel out in the hallway, you know, I think I'm about one of the luckiest guys in the world, because the leader that we have at the State Department in Colin Powell, we've got, I think, one of the best leaders in the world as my immediate boss. And I can tell you something that I hang on to every word that this fellow says. And my colleagues, at any particular time, Morgan or some of his other colleagues can find themselves in his presence and working with this fellow, well, with the secretary. And the way that he works and uses people is pretty well the same, and it's pretty well documented. I say that to say because I heard and know for a fact that the Secretary Powell, practically threw his body in front of moves or motions and suggestions to have the visa function taken out of the State Department. And he went to the mat on that, and we know that for now he has won.
So, given the fact that there's no wiggle room, as you say, in a situation that arises frequently in Canada, an Iranian national or Pakistani national is in Canada on a work permit, awaiting the issuance of their immigrant visa. They receive their immigrant visa from the Canadian Council in Buffalo. In order to activate the immigrant visa, they have to exit and re-enter Canada. Most frequently, we used to advise them to make a U-turn around the border, but that requires them actually entering the United States for maybe 5 minutes. Now, pre-September 11th, some people used to just go to the United States, tell them, listen, I just want to get refused entry so I can make the U-turn. The officers would give them refused entry, they'd make the U-turn around. But according to what I'm hearing now, this Iranian national or Pakistani national has to go apply for a visa entry process, go through approximately 4 weeks of security screening because they're on one of these listed countries, then get a visa, go to the border, be in the United States for only 5 minutes, and potentially have to register to enter and register when they leave too.
Go. Yeah. Somebody, and I didn't really hear a question, but someone in the audience, to see how much, I want to know whether you got it. All right, so I'd like for you to address what she's talking about. Let's have a little interactive discussion here. Who would like to respond to that? Okay?
There's no room for maneuvering. You can't just expedite perhaps.
Well, it's
All right.
interesting that Howard said yes, and I'm sitting here going, I'm not so sure that you couldn't still get away with that.
All right, let me ask you a better question. Pardon me?
Withdrawing your request to enter, so you go over, you go across, but then you decide you don't want to enter, you withdraw.
Whoops, I needed a visa, sorry.
Yeah, wouldn't that still be possible?
Maybe.
Not entering.
Certainly not
All
your
right.
concern, but
All
it's-
right, let me ask a more fundamental question. What do you think, given the scenario and all the background of that, what do you think is the right thing or the best thing that should be going on at that port of entry in either one of those situations? Either one of you can comment. Jump in.
Allowing them to withdraw their entry and return to Canada so that they can become a landed immigrant, because they're not a security threat to the United States if they're not entering the United States.
Yeah, but that's not the point. Her point was that you need to get to the Canadian consulate in Buffalo to get the visa.
No, she's already.
It's just a turnaround point,
She's turning around.
because technically you
Oh, I see your point.
but do we have any experience that's
Yeah.
not working?
Well, I actually had one story where they were refused entrance to the United States, but instead of being allowed to drive around the border so they can still activate their visa, the INS officer, as they were then called, made them drive backwards back into Canada, so they never really got to
This is really a question
the
for INS. We never deal with this sort of thing.
You know what? First of all, this is really a former INS matter, and I think that we shouldn't make doctrine on little small things. You know, so that's probably such an isolated situation that I'm not sure that it's really worth your while to try and come up with a grand strategy for the few times that kind of thing happens.
saying then that if you wouldn't mind, well, you wouldn't advise against people just going to the border saying, excuse me, can I just make a U-turn around this border, even though I may not have the visa, and even though I'm not going to registration procedures.
I wouldn't do it personally if it was me. No, ma'am. That's-
Michael?
Thank you, Bill. This is a question which I don't think is security related, relates to the Toronto consulate here.
Okay.
Many of us obviously apply for our clients for L1As and L1 visa inland service centers, and we say we want the processing, thank you, at the Toronto consulate, obviously. And I'm wondering, when we get the notice of action and then they're now, calling in or getting their appointments, is it still more or less a formality because it's been approved inland, or is it becoming more than just a formality to get the L1B through the Toronto consulate, or L1A through the Toronto consulate now?
Well, citizens of what country, for starters?
No, obviously, because it's inland, they're not Canadian
I
citizens.
know they're not Canadians, but
Well, they're on the let's say with the waiver, they're on the waiver list. Those nationals that aren't Canadians.
Okay, the approval of the L1 petition by INS does not relieve the applicant from qualifying for the visa. It's two separate and distinct processes. So we don't rubber stamp L1s or H1s or any other petition-based category. We do a careful evaluation of the qualifications for the category, and then based on that, we decide whether they qualify for the visa or not. So no, we don't rubber stamp.
but nothing's changed in that regard.
No, I understand. I just wanted to see if anything had changed.
No.
But what about now when we have nationals that are on the registration list? Does that make a difference? Has anything changed?
4 to 6 weeks of waiting for the security check,
Is that what it is now?
That's correct. That's
Yeah.
correct.
Okay.
without the ability to return to the United States while it's pending.
No, of course.
Because technically, it's a refusal until it's approved.
That's why currently we are canceling appointments from countries of concern if they are currently in the United States, because we don't want to impose that on them. A lot of people in the past have showed up with young children, whole families have traveled and they didn't make accommodations for clothing or accommodations for an extended period of time. So temporarily, we have been canceling appointments from the U.S. if you are a permanent resident of Canada or here on a work permit, and then we could accept the applications.
Well, when they come in, should we tell them to bring in their fingerprints with them?
No, the fingerprint has to be taken at the U.S. consulate.
Okay.
How do we know it's their fingerprints if they bring them?
Yeah.
I have a question for Morgan Hall about the E2. I was surprised actually that the number for Canada last year was only 1,900, and I'm wondering how these changes will affect things. And if I could just ask you about an example of, say, an Ontario corporation that qualifies under the investment requirements, and a company whose investment is growing in the United States. I'm one who has never processed an E2. I'm interested as to that definition of primary applicant, and for that example, Ontario corporation, what can it expect going forward from now in getting the E2 applications processed, and how many employees of that company can benefit from it?
Well, there've been no changes really in the E2 criteria. The processing will be the same, with the exception that they'll have to come to the consulate for an interview. When I say primary applicant, I mean excluding the dependents, family members. The primary applicant can either be the principal investor, or an employee in a supervisory or essential function in the company. And their dependents would also be able to go to other posts. When I say primary applicant, I just mean the individual who has a role in the company. Now, the number may rise, I think, in the E1 category. I think the E2 will probably remain more or less constant, because there are companies, I think, who have been accustomed to going back and forth in the past without too much trouble, and there may be a perception now, I've heard anecdotally, that people are having more trouble going in and out. And companies who aren't actually setting up shop in the United States, but do frequent trade with the U.S. and either in goods or services, may find that an E1 works to their advantage because it'll help them at the border. But I don't anticipate a big increase in the number of E2s, because for an E2 is a very different kind of category. Someone's actually coming and starting up an investment in the United States, or bringing in employees who are essential or in a supervisory role. So it's the motivations behind E2 visas probably remain the same. The U.S. economy is, well, now the Canadian economy is growing faster than the U.S. economy, so there may actually be a shrinking in the number of E2s and a growth in the number of E1s.
How long will that process be taking now going forward, processing E2 applications?
Well, from the point at which we get a complete application, which means we have a pile of documents related to the business, we have all the forms filled out and the photos and the passport information. Right now, and fees paid for the application fee. Right now we're at a backlog of 4 weeks. We've gotten the backlog down over the last couple months. We're trying to get it down to an even shorter period of time. The processing itself, then, that doesn't take into account the time that the applicant will have to take to actually come to Toronto for the interview. But our plan, and we think we can do this, is to actually interview the individual in the morning and give them the visa in the afternoon, so that they won't have to spend the night in Toronto.
Thank you.
By the way, we should note that Morgan Hall almost single-handedly has reduced the backlog from 5 months down to 1 month, and we thank you for that dramatically. Howard, if you want to continue the round table panel at this point, or how do you want to run it? Fair enough.
Can I just ask a clarification? Did I understand that your Pakistani national landed immigrant of Canada applying for a visa to go to the United States must apply in person?
That's correct.
In person, not in writing?
Actually,
Depends.
anybody between the ages of 16 and 60 must now apply in person, regardless of nationality, regardless of gender.
And make an appointment in advance or line up
Make an
on
appointment in
Simcoe
advance.
Street?
Yeah.
Appointment.
Yeah, we do have some handouts here if anybody's interested in collecting them. It's obtaining a visa at the consulate. And the other list just talks about the more recent changes affecting the British Commonwealth countries.
Yeah, I should mention that applies to E's as well. If the applicants are under the age of 16 or over the age of 60, they don't have to come in for the interview. So many
Question.
dependents will.
Sure. Yes.
My understanding is yes.
In fact, the ports of entry are saying now, they're warning people,
Yeah.
after the 17th, you're in trouble, and we'll let you in now, but you've got a few more days.
Just one other question, a little off topic, but if, what's the consulate's policy, or has it changed with respect to visitors to Canada who want to apply for a visitor visa to the United States? I know the majority of those cases are heavily scrutinized. But let's say the client has an interview at the Canadian consulate for a permanent resident visa or for a live-in caregiver application, which is very much the case. How are they treated now?
Not any differently than before,
I'll sort of share. Basically, they have to overcome the presumption that they're not an intending immigrant. And, you know, when you look at it from a very subjective standpoint, it's very difficult for a visitor in Canada who's trying to establish ties here to overcome that presumption based on their history. If I were to offer you, you know, statistics, whatever, sometimes it's just hard to say. We sort of take it on a case-by-case basis. We've worked with the Canadian consulates in Buffalo and in Detroit. We go there, they come up here, we talk and look at profiles and cases so that we can try to get it right as much as we can. And we don't want to stand in the way of a person who, you know, is seeking to legitimize their status in North America. But, you know, sometimes there can be a slip between the cup and the lip, and that's what we're trying to be concerned about.
Still some wiggle room in that. Well, we've got lots of other questions, so let's move on. Charlotte?
Sorry, I've asked this question earlier, but because no one has an answer, we thought maybe you could shed some light on the special registration procedure. If someone, at the moment, they're registering on the way in and on the way out, and there was a letter distributed earlier by Ms. Segal suggesting that there is going to be a waiver application that can be made, so you don't have to do that if you're a frequent traveler to the U.S., but you fit the profile. What we don't seem to know is how we will be able to go about and apply for that waiver and what will be required. And I guess even secondly, you know, what type of person might qualify for it?
Yeah, that's a good question, but actually you're asking the wrong person. We thought about this last week, actually, in a case that was came to our attention. We're aware that there is a waiver provision available that the director, the then district director of the Immigration and Naturalization Service could authorize. At the time, and given their transitions, we still don't know how that's going to sort itself out and what criteria that person will use in making those determinations. We know that in this particular region, Francis Holmes, M. Francis Holmes, is the district director and will retain responsibilities for the most part under the new organization in Buffalo. And if that responsibility for NSEER's waivers remains with her, then the question would be, Fran, what are you looking at and under what circumstances will you make those determinations? And I'd like to know that myself, actually.
Great, so at least now we have a name. Thank you.
Asher? Sorry.
Do you have any idea what impact March 17th will have on third-country national processing visa secrets from the United States coming out of Toronto? In other words, if you're going to get an onslaught, if you're going to be faced with an onslaught of landed immigrants from Commonwealth countries who suddenly now require visas, will you still have room to be processing TCNs from the U.S. coming up here?
Althea is in charge of our appointments. Why don't you talk about the appointment numbers?
We increased the numbers effective last Monday to accommodate an expected increase in for the land immigrant countries. We did not touch the TCN numbers. So
third country nationals.
Sorry, third country, speaking in-house. Third country nationals. We didn't touch that number. So
and what is that number?
We've increased it by 100 appointments a day. And right now, we're comfortably watching that, just monitoring that situation. we're just seeing the numbers starting to climb us up tomorrow and Friday. The 100 is pretty much gone by Friday, so we'll be monitoring that, and then based on our existing conditions at the concert, because we're undergoing some major construction right now, and we are strapped for interviewing space and computer supplies, etc. So we'll be monitoring in-house conditions and seeing whether or not we can increase those numbers any.
Of course, the timing couldn't be worse. You're faced with March break at
Yeah,
the same time as
that's
you're faced
true
with the
too.
change.
Would you
in-
anticipate that the onslaught will be front-end loaded? In other words,
We think
immediately
so.
after
We
March
think so.
17th, and then it'll kind of peter out
Maybe
over?
for the summer we would expect a heavier summer than normal, but I would certainly think that by the fall we should be back to manageable numbers again.
Yes, sir.
Will visitor visa applications be available on the Toronto consulate website?
Yes, again, that information is provided here. We have 2 websites where you can actually download the application forms, which is the www.travel.state.gov and the www.amsits.com. Those 2 websites, you can actually download the application forms. It's www.travel.state.gov and www.amsits.com. We also have an off-site service provider. That's www.nvars.com, nvars.com. That is a pay-for-use service, though, the last one.
Could I have a supplementary question? U.S. citizens whose passports may have lapsed, there used to be a mail-in procedure available. Is that going to be the case anymore, or are they going to be required to appear in person for renewal of their U.S. passports? I'm thinking particularly people outside of...
Yeah, we don't have any procedures for not requiring interviews. We have mail-in applications still available for U.S. passports. It doesn't mean that it won't change. I've not heard anything to that effect. But in terms of post-September the 11th changes, for your information, the U.S. consulate now no longer processes or prints the passport at our office. We now ship those things off to the states, and the printing is done at the National Passport Center in Portsmouth, New Hampshire, because they have the technological equipment to do machine-readable passports with digitized photos. It's a more secure travel document, and so rather than try to distribute that equipment all over the world, we just move the passports there.
Of course, then they send the passports back by ordinary mail. No, I'm kidding.
Right. The passport applications themselves, are they going to be available online for U.S. citizens?
Yeah, there are U.S. passport applications are available online, but I'm not sure exactly what the website is. I would refer you to www.usembassy.canada.gov, and you probably can find links there related to that.
Okay, thank you.
Just wanted to say the e-visa application, they will not, their appointments will be scheduled by the e-visa unit. Everybody else will be either going to the WWNVARS site, or there is a 1-800 number where you can book appointments for all other visa categories other than the E category, and that's 1-900-451-2778.
I'd encourage you to get one of these handouts, and all that information's in there.
Right, and for e-visa appointments, we'll contact you to let you know that it's time for an appointment to come in, and then, but up until that point, it's still all done through the mail.
Morgan, just I believe, correct me if I'm wrong, that any application for an e-visa filed before March the 17th will not require an interview.
With a login date before March 17th. If we log it in before March 17th, it won't require the interview.
Just one quick question. You indicated that the visa waiver program will still be maintained. It'll still be alive and well. But in light of, let's say all the fuss at the border, if you have an individual from a visa waiver country and they wish to apply for a visa through you, would you be willing to entertain it?
Yes. That has not changed. That has always been part. And sometimes it's required, visas are required if they're going to stay longer than 90 days or their purpose is for something other than business or tourism.
Because there have been instances, I believe, where the consular officer would say you don't really need the visa, apply at the border, But, you know, in light of heightened security and procedures these days, you can probably understand why certain individuals would like to have the comfort of a visa and the passport, if possible.
And the ground is starting to shake under the visa waiver program, Asher, largely because by October the 1st, 2003, countries, including visa waiver countries, must have machine-readable passports that have certain security features in it. And if they do not, then they will need to apply for the visa. That's an issue that we've just broached as of yesterday, and the potential impact that can have, because some of the countries, the Norwegians have told me just yesterday that we're not going to make it by that date. And there are somewhere of more than 100,000 Norwegians in Ontario. And you've got to... Oh, yeah, that's what I've been told. I can only go
There's
by
not
that.
100,000 Norwegians in Norway.
They're all here.
Yeah.
All right, there's a question there.
Presentation of March 17th, can a resident schedule an appointment for a visa, like now or in advance? Would the appointment have to be after March 17th?
No, they're taking those appointments now and have been for a little while.
Except for blanket Ls.
That's right.
Yes,
We don't
one,
have
two.
jurisdiction to
Yes.
handle blanket ads until March 17th.
Whoever gets first.
Debatable.
No.
And
For what?
an expiration date?
Yeah, in terms of the length of stay that you can have.
Yeah, the visa has a validity date on it. So if a person is a national of Jamaica, for example, but a landed immigrant of Canada, the reciprocity or the validity length of the visa actually can be up to 120 months or 10 years, which is what the reciprocity or the validity length allowed for Canadians. But let's say you don't want to, they don't give 10 years, they might give 5 years. It's up to them. But what that means is still, that's just how long the visa is valid for. When the visa holder shows up at the port of entry and stands before the inspector determines how long the stay will be on that particular trip. The person goes, stays for that length of time, leaves, and then as long as the visa in the passport has not yet expired, they can return to the port of entry and go through that process all over again.
Yeah, that's the same as in Canada. Yes, sir.
What's your process for visa applicants who require criminal waivers? Do you send that to the district office of now Homeland Security, or what happens, and how long does that take?
Althea, or...
Right. We sent it in the past to the INS office in Buffalo. There are going to be some changes now in the way that's done, as I understand.
That's under debate right now. Yeah.
But we will continue to forward the waivers to the responsible authority, and they've been taking lately they've been taking
2 weeks.
2 weeks.
About
something
2
like
weeks
that.
to give us a response.
Earlier you suggested that you're making an appointment for a visitor visa for a third country national, that you just give them 4 to 6 weeks and, and do the special registration procedures. But in your paper, at the top of page 3, you suggest you won't make appointments for citizens of states lost to terrorism. Can you just clarify exactly? For example, students from international, a lot of nationalities on the registration.
See the state's
Students studying in Canada on a student visa, will you not make appointments?
Just to clarify, what happens is that people under the age of 16 and over the age of 60 can still qualify to submit their applications through a travel agent or by mail. However, citizens of these 7 countries cannot do that. They must make an appointment regardless of their age and regardless of their gender. So that's the distinction we're making there. Just for the, they have to make an appointment. Basically,
Yeah,
they
but
have to make an
just to
appointment.
clarify, what they're talking about are people who are those citizens of countries who are in the United States. They will not allow to come to Canada because they may be here indefinitely.
Yeah. That's right. We still continue to make appointments with people.
And I do that as much because I don't want the Canadian government pissed off at me for opening the door and bringing a bunch of people here and essentially stranding them.
Yeah.
Well, great. Thank you, panel, so very much for taking your time to come out this afternoon. Thank you.
We had in mind a roundtable at the end, but we took so much time in questions for each panel that I think we've flushed out most of the issues. So you have some evaluation forms you can drop in the box if you have a chance, and otherwise, thank you very much for coming.